240201, Anita Hammonds v. Tribal Council. Justices Donna Jacobs, Kelvin Jacobs, and Chief Justice Mark Brooks.
Good evening again. Is March 28th, Thursday, March 28th, 2024. And this is the Supreme Court of the Lumbee Tribe of North Carolina. Today we have a hearing. And this is versus the Lumbee Tribal Council, who are respondents. Here's that Ms. Blanks is present. Here's that Speaker McNeil is present on behalf of the Tribal Council. We'll go through a few housekeeping matters, and then we will begin with the substantive content of the case. Again, this is the Supreme Court of the Lumbee Tribe. We are short a member tonight due to a emergency. Mark Brooks of the bench. I am from the Pembroke community, and I will ask both of the judges who are up here with me identify themselves and tell me where they are from.
Evening, everyone. It's Kelvin Jacobs.
Before we get started, let's address potential conflicts, potential reasons why persons that are on the court may or may not be to hear the case impartially. So I would invite myself as well as other justices have a known conflict or conflict, aware of it. Hearing none, we would invite parties to announce if they believe that there is a conflict. Blanks, we'll start with you. Counsel, your comment. Okay, thank you. This appears to be somewhat of a straightforward petition. We'll make some opening remarks, sort of give us some kind of parameters. It appears that this petition, and you feel free to correct me at any time, specifically references a single ordinance, Ordinance 2005-0002, otherwise commonly known as our elections ordinance. And in particularly, I believe the section that you are contesting is section 2, subsection 4. And that is an amendment that goes back to 2019. Is that correct? And I'll just read that amendment.
I know up there on behalf of the council. You state that ordinance is the subject matter of petition.
Yeah, I'm just making just some initial introductory remarks so that the court and the parties, blanks as the petitioner, the council as the respondent, just to make sure that we kind of narrow the issue. And as the court sees, that is particular tribal ordinance that she is specifically contesting.
I would ask that Fairfax what Columbia constitutional or tribal ordinance has been violated in ordinances.
Can you restate your position, Mr. Locklear?
I think it would be premature to assume that that's the ordinance in question. The document that was filled out by a petitioner has a section that particularly states one section of the constitutional tribal ordinance has been violated. That particular ordinance was never stated in the section cited.
Are you raising that as a motion, preliminary motion? Are you raising that as, because looking at the petitioner's complaint, it does appear that Ms. Blank's alleged fairness to me on the petition, a line there. She does specifically state there in the explanation, part 20, dash 0002, disqualification alternate, subsection 4, board members shall not be run for tribal office, tribal council or tribal chair, following the position, Mr. Locklear calls that as improperly pled.
I do believe it is improperly pled, but in regards to, and I was trying to determine if we were moving past the first section, we weren't acknowledging that.
Yes.
And
yes,
moving
okay.
straight on
All
into the other section. That's your other question prior about a preliminary motion. I did have one. I don't think now would be the appropriate time.
Okay, so let's do. I think that it's helpful for the court to ask some of the murky part of the case, try to get directly to the part of an issue. Here's to the court that is the heart of the issue. I do believe Mr. Locklear makes a valid point. A strong preliminary issue. So, in light of the fact that that's the court's impression, what we'll do at this time, I will invite you, Ms. Blanks, as make a statement, from the court, why it is that you're here, what relief that you believe, or what you believe that has been done wrong, what relief that you're. Thanks.
Yeah, Mr. Needed, just press, if you just want to press that button, it should.
Does it be read? Okay. I'm here because the Constitution of the Lumbee tribe, as is stated in the Constitution, that the members of the tribe shall be secure in their persons and property, and such security shall be preserved by the government created by this Constitution. And in Ordinance CLLO 2005-0002, amended March 21st of 2019, which they stop board members from being allowed to run for office does not give tribal members security. They are not, you're not free. You don't have justice. You don't have security in your person if you cannot run for office. And I believe that the rest of the Constitution, the rest of the information in the Constitution clearly shows that the intent of the Constitution is not to dissuade anybody from running for office. That the authors of the Constitution clearly state who is eligible to run and who is not eligible to run. And it is my belief that this clause in this ordinance is unconstitutional and that it should be stricken by the court, and that the tribal council should be told that they would not rewrite it to impose any other restrictions on board members to so that they would not be able to run for an elected office.
Barclay.
Nuisance. And your law clear. Response to that, I would say that Article 3, Section 2, as proposed by the petitioner, I don't think that's the proper article. Gives way to the amended ordinance. In that, securing their persons and property. If we look at Article 3, Section 2, the members of the tribe shall be securing their persons and property, and such security shall be preserved by the government created by this Constitution. There has been no injury to anyone's person or their property. No security was severed by the ordinance. The ordinance itself doesn't banish anyone from running. It doesn't disqualify anyone from running. It may condition your running, but in no way is it removed your right to run or ability to run. So I don't think that basis of the petitioner's argument would sustain her objection to LLO 2005-002, the election ordinance itself. Apples and oranges, in my opinion. If you look at that, how it's typically used, how its phraseology is used in legal situations or circumstances, that's typically involving a seizure. You state that you're securing your persons and property and security will be preserved. They haven't been seized of any right. Nothing was ever taken. Elections ordinance merely conditioned your ability to run. It never said you couldn't run.
In light of that, Mr. Locklear, you asking that the court entertain best matter for get her properly pleaded.
Your Honor, I am making a motion to dismiss the matter on the basis that it is improperly pled. Secondly, that it fails to state a claim upon which relief can be granted, because if you examine the document, if the court just takes a moment, examines the petition itself, I think throughout the entire document, it's a recital of law. There's never given any facts to substantiate these allegations. At no point did the petitioner identify herself as having been harmed or her right to run have been removed. No action taken by this council touches upon her, the petitioner herself. And if we broaden it out and you take everything in the petition itself, it still doesn't eliminate someone's right to run. So if you look at the relief being sought, ordinance is written as a violation of members' constitutional rights as stated in the preamble. The preamble itself doesn't confer a right, merely an introductory statement to allude to the guiding principles of the document. Logging. So number one would eliminate itself on that basis. Number two, the ordinance is written violates the member's right to be free in their person. Haven't severed anyone's right to freedom by this ordinance. There's no factual basis to establish that having occurred. No facts provided to substantiate that they were not securing their persons or she wasn't. Title of the ordinance itself doesn't provide any explanation as to how that's a violation. It just merely states it as such. I think that's presupposed some factual basis. The court has made arguments in prior cases. I think I referenced one in my original answer. In 2020-003, mere allegation without enough facts is simply not reviewable by the court. Stated in that case, its duty is only to determine if an act described with particularity amounts to an actual case of controversy. So I think the first thing we need to determine is whether or not this petition itself satisfies the requirement of the court that it be an actual case of controversy. Without any facts, it's impossible to establish that. No facts were submitted in the petition itself. And even after it has been, I think, now a month and a half or so since this was filed, it was never amended to include any factual basis to support the allegations in some way that this ordinance is a violation. So my issue itself is that if we examine the document on its face and take it as pled by the petitioner, it substantially fails rise to a justiciable case or controversy before the court. What she's deeming as an issue may very well be one. This petition itself fails to rise to the occasion claimants that an actual case reviewable by the court. Its deficiency where it fails, not in its substance. The petition itself fails on. That would be our position before we get into the substance of it.
Ms. Blank, before I do so, for either party. Hearing none, I know that was a lot. You have a response to three.
One of the things that needs to be brought out in the Lumbee Tribal Court, Supreme Court, is that when you look at this Constitution, there are 3 lay people on the tribal court and 2 folks who have graduated from law school. There's a reason for that. There's a reason why they put more lay people on the court than they do people who have law degrees, because they knew you'd have people like me who are going to come in here with petitions, not with an attorney. I don't know all of his terminology because he's using legal terminology, which this Constitution knew would not be the majority of cases for people who would come in here and bring these petitions. And so, to me, the court has to take that into consideration when somebody makes a petition. Most of the cases, and I'm sure you know this, most of the cases who come in here for petitions from tribal members do not come in here with an attorney. So the first place he went was to law school. That's where he went. He didn't go looking at what does the Constitution say? How do we handle this like Lumbee people would handle this? Lumbee community would handle this. That's the way the court should look at any petition that comes in here. Should never have a situation in this court where they tell a member of the Lumbee tribe, you don't have standing. This is a baby Constitution, and it has a lot of growing to do. So you're going to have petitions, and you're going to have people like me who come in here who don't know all the legalities of the terms that the attorney is sitting over there using. You just come in here and you say, okay, I've got a petition. I think something needs to be addressed, and the court needs to hear those petitions.
I think the court certainly hears. Mr. Locklear's position. I don't want to.
In that argument, I particularly said at one time, if you read everything that she had written, it doesn't require a law degree. It doesn't require any specialized knowledge. The argument was going to be on the ordinance. Put the ordinance where it says violated. Everything on this rule still doesn't offer what it is trying to accomplish action. Because if relief sought that this ordinance 2 years as stated was the problem, thought would have been typically death without everything else in. Isn't complicated. Isn't legal analysis. This is just, let's just read it, and it doesn't flow. It doesn't belong. The ordinance is in the wrong section. There was no explanation. There had been a factual explanation as to how this ordinance violated. It was a violation. Never stated once this has caused a problem for any person, or as we saw in this election, none of the facts are there to substantiate. Just the law. She took the law. She brought the law here. She placed the law in this petition. Then she said, let's not look at it legally. I don't understand how you can both of those breaths.
Ms. Blanks, is it your position that you have standing in favor of being a member of the Lummi tribe? Is it your position that that because you believe the constitutional ordinance has, or that a ordinance has been adopted by the tribal council or an act by the tribal council, essence violated either the or an ordinance, you believe that that violation in and of itself puts you in a position where you have standing to ask for remedy? Mr. Locklear, you stated that you believe that in the part of her petition, in what section of the Constitution or tribal ordinance has been violated, you specifically say that her position in Article 3, Section, in quote, powers necessary and proper to the exercise of those powers by the branch of rural membership of the tribe of North. Those powers not delegated in are reserved to the tribe. You believe that that provision that she has provided in her petition, I think you said that it, what was your position on that?
The ordinance, what it was under attack. That's where the violation was. Because that article, there's no point that we stated section 1 in violation of any. She never said that. She said that ordinance was. That's why I said as to court examining this on, I don't see where those would, that example. Brought in as an argument against the ordinance, but yeah.
So in other words, you're saying that the tribal ordinance 5 in and of itself is not dependent on Article 3. And that's what she's alleged. I think it would be appropriate if the court would
Yeah, just so I understand better for question. Are you saying based on the petitioner's petition that it's just
I went further than that and stated that even if allow it to be there, it wouldn't rise to an actual case of controversy. Bring this claim because there has been no deleterious effect. And I understand what you're asking in terms of just in general membership as a member of the tribe itself. But if we go back to your case law, see where they required there to be some factual basis rise to it. The existence of it weren't enough. There had to be some factual basis by the court established it.
by case law, is that
Yeah, that's like we can. That's the one I particularly.
you offer that case so that there is a requirement of and in order for it.
There has to be an actual diversity. And it doesn't explain that, so we'd have to then want to push it on an actual case of controversy into that, but that's a whole nother.
Recall this.
She had an issue with work allowed to be present at those meetings. She was stating that title of them from work session. They're not allowing in the public what's going on. That was what the bonus.
There a tribal council ordinance, recollection that she was listing work session.
It was Article 7, Section 5 of the Constitution.
Other question. We're going to take a recess.
All rise.
Be at ease. Appreciate your patience. Walker, I and as well as the other justices believe that you make a very compelling argument. At least as it relates to, this is a court that does not entertain frivolous, unripe matters whereby this court can be expected to provide relief, not be any harm. But the justices believe that Ms. Blanks makes a very compelling point also when she says that the court is not simply a court responds to things as a matter of I's and T's and nuts and bolts. If we were in the state court of North Carolina, Ms. Blanks, and we Locklear, and I believe that I believe on the substance of what he's saying, he makes a very strong point when he's making the case. Has to be some type of harm here. You allege in your petition that you, on March 21st, 2019, amended the ordinance CLLO 2005-00. You specify the section. Disqualification and replacement of board and alternates. A board member shall not be eligible. Court does believe that that should have been alleged in the upper part of the petition. We agree with Mr. Locklear that we don't specifically believe that Article 3 and Section 2 is necessarily implicated by that ordinance. That specific ordinance. As it relates to the Locklear case, we believe that there is a strong distinction between that case and that case. The court did not decide that Ms. Locklear did not. The court decided that Ms. Locklear failed to present enough allegations with particularity, whereby if the court, even if the court were to find them as true, the court couldn't decide whether or not. Ms. Blanks, however, has alleged that the tribal ordinance 2005-002 on its face is unconstitutional. Now, it may be or it may not be. But she's made the case that it's unconstitutional because is that it is a violation of a member's constitutional right in order to run for office. We may not necessarily agree with you, Ms. Blanks, at this point. We yet to find out. But I do believe that you state, and the court is unanimous in this, the court believes that your pleading is sufficient enough to block clear. And in light of that, your presentation, Mr. Locklear will have a chance.
I would ask the court to give me a little indulgence. I'll keep putting my glasses on and taking them off. I had cataract surgery, so I can see you all fine, but I can't see a thing up close. First of all, in this ordinance, in this election ordinance where the board member shall not be eligible to run for office, to state that in the Constitution, it says that the members of the tribe shall be secure in their persons and property, and such security shall be preserved by the government created by this Constitution. How in the world can you be free in your person? And I understand he went back to the Fourth Amendment of the United States, but we're here in Lumbee land. And so when you say being free in your persons, it doesn't necessarily mean the same thing that the Fourth Amendment means in the Constitution. And so being free for Lumbee people means being able to vote, because we all know that many years ago, Lumbee people couldn't vote. So it's a big thing to be able to vote. So in taking that away, that makes it unconstitutional. And then you look at the powers, the separation of powers in number 3, and it says that the powers expressed herein and those powers necessary and proper to the exercise of those powers expressed herein are delegated to the specified branch of government by the general membership of the Lumbee Tribe of North Carolina. Those powers not delegated herein are reserved by the general membership. Well, then let's look at what the tribal council's powers are, and they're expressly spelled out in this document. And I'm actually looking at the Constitution here. And it starts off with that the tribal council they have the power to write an ordinance to disenroll members. This is in Article 2, number 2. They have the power in Article 2, number 5. They have the power, it says the tribal council shall have the authority to enact such ordinances governing tribal membership as are consistent with this and other articles of this Constitution. Both of these state expressly that these powers are given in accordance with this Constitution. They make it very clear. Every ordinance you write has to be under the umbrella of this Constitution. Go to Article 7, which is the Tribal Council article, and it says that they have legislative power that give them the power to enact ordinances. And under those ordinances, they have the power to enact annual tribal budgets. And they give another provision, provided that these budgets are enacted into tribal law following the conduct of tribal hearings. They're putting parameters on the tribal council's powers here. They have the power to adopt rules and regulations governing the tribal council's procedure and decorum. Again, consistent with the provisions of this Constitution. They have the power to confirm or either dismiss the tribal administrator. The tribal council has, it says in Article 7, number 2C, the tribal council shall have authority to enact an ordinance governing disqualification from tribal council office due to felony conviction. It also states in number 3 of Article 7, the tribal council has the power to draw the boundaries for the districts, which they are actually doing right now, in accordance with the provisions in Article 12 of the Constitution. Still, the parameters we see, they have to stick to what's in the Constitution, what's stated here, the powers given only in this document. Also in number 7, under Article 7, it gives them the authority to nominate somebody if there's a vacancy in a seat, a tribal council seat of less than a year. And when you continue over to Article 8, number 2, again, they state the tribal council has the authority to enact a tribal ordinance governing disqualification from office of tribal chairperson due to felony conviction. Stated clearly, here's your power to stop somebody from holding an elected office. There's 2 instances there. They make it very clear there what their powers are. They have the power to appoint Supreme Court justices. They have the power to appoint election board members. And they were told specifically to adopt an ordinance prescribing conflict of interest for elected and appointed tribal officials, and then even given the outline of what was going to be in that ordinance. You see everything in this document is saying, here's your powers. Here's your powers, and your powers are spelled out in this document. Nowhere in this document is there any item that dissuades anybody from being able to run for office, except with the exception of somebody who has a felony conviction. And also, they don't tell you that you have to write an ordinance that so that somebody with a felony conviction would not be able to. It says you have the power to do it. The tribal council could have chosen not to do it. But of course, we know that they did in September the 9th of 2003. And so we see these powers that are given to them expressly. And so you see those powers. Well, then let's look at the Board of Election, because now we've got Board of Election members who we're saying, you know, if you can't run for office for 2 years after you finish your 6-year term, or if you resign, then you're not supposed to be able to run for office. Well, look at the powers that this document gives to the folks on the Board of Election.
I interrupt you.
Yes.
I think it would be very, very helpful if we narrow this issue.
Mhm.
What this issue in this case. This court can only hear matters that is case or controversy that arises either from the Constitution. This case is about CLLO 2005-0002. Okay, that's the election ordinance.
Mm-hmm.
Specifically, it's about Section 2, subsection 4, is this language. Disqualifies persons on the elections board from running for office. Let me read it. A board member shall not be eligible to run for tribal office, tribal council, or tribal chairman for 2 years following the expiration of their term on the pledged on your.
Mm-hmm.
I've never heard your argument before. I've never heard the argument before where you've made about persons being secure in their persons. I think it's intriguing. Locklear is right that generally when you're thinking churches, you're thinking about seizures. But I think that there is something to be said about whether or not that security of the person's right to vote. I don't want us to get long. Locklear will pontificate extremely well about all that means, and we won't get nowhere close. What this case is about, though, is whether or not this ordinance, ELLO 2005-0002, does it violate Article 7, Section 2, which is what you just read, qualifications of a person to run for tribal council. That's what the case is about. I don't think you disagree with that.
Okay.
You disagree with that? Whether or not this ordinance that says persons named to the elections board cannot run for office
Mm-hmm.
if they have been on the elections board or off their elections board. Wouldn't disagree. You believe that that's in violation of. Locklear, do you disagree? That really what we're here for, what this case is about, is whether or not this elections ordinance 2005, the amendment, which is Section 2, subsection 4, says that no member of the elections board shall run for office for at least 2 years after serving on the election. The question is whether or not that's a violation of Article 2.
You're asking if I agree with that on this hearing?
Yes,
Yes, I agree.
focus on that. Let's focus on that. And I think you've stated sufficiently at this point, Ms. Blanks. I want to give Mr. Locklear a chance to ask you some questions as it relates to how Section 2, subsection 4 of this ordinance may or may not violate 7-2. Take your time, Mr. Locklear.
And I'm trying to process everything you went over, but I want to specifically ask, are you stating that the only limitation the tribal council can confer on an election in terms of who can run is whether or not they're a felon based on the Constitution? You're stating that's a specific power given by the Constitution to the council, correct? The felony rule, do you see or foresee any other time that the council could put in place an ordinance that would limit someone's ability to run outside of the felony rule? Would you agree that the Constitution granted the power to the tribal council to create an elections board?
Hey, can you turn on your mic?
The Constitution creates the election board.
What governing body would it fall under?
The election board, it falls under the governing body of the Constitution and the ordinance is what it says.
So you would agree then that its actions have to fall under the tribal ordinances. Is that correct?
As long as the ordinance is under the auspices of the Constitution, yes.
Who has the power to author such ordinances govern the elections?
The Constitution states that it is governed by the Constitution and the ordinances.
Would you agree then that the tribal constitution authors ordinances?
Or could you repeat that?
The Constitution gives the power to write ordinances to the tribal
Yes.
council. And such ordinances are authorized under the Constitution to be observed by the Elections Board per Article 10.
All ordinances are supposed to be written under the umbrella, under the powers given by the Constitution.
To agree, tribal council writes ordinances. The Elections Board then has to adhere to.
That's why we're here tonight.
Yes or no, duty or don't.
Look, I'm not on trial here.
I'm asking you a question. I mean, I simply want to know, there has to be some authority, right? The authority is conferred by the Constitution to create an elections
The
board.
election board
Hold on.
is run by the Constitution and the ordinance.
Yes. We agree to the ordinance is something that has to be observed by the elections board.
I think in fairness, Ms. Blanks, he has specifically alleged that the tribal ordinance that the elections board is being asked to follow unconstitutional. So in light of that, I think she can easily say, yes, the elections board is supposed to follow ordinances as legislated by the council. In fairness to her, the whole case is about the fact that she's stating that it's constitutional.
Correct.
And based upon everything that she testified to previous to my asking questions, I could in no way discern how it's unconstitutional based upon what she said.
And I,
I don't know where it's at or where she's stating that it's unconstitutional because whatever the reason may be.
okay,
She just said it was, and and I'm trying to figure out
okay,
why.
okay. Then let me give you an example. And this is the court, and I don't have it in black and white. It was the 9/24/2020 case, which you sat in on. This was Reginald Oxendine versus the Board
Yes.
of Election.
I recall it.
And yeah, it was audio, bad audio in the gym.
It was long audio.
It was a long audio. Um, in that case, which was the situation where Richard Jones resigned from the Board of Elections, to run for tribal council. Reginald, based on this item in this ordinance, filed a court case because he said he had to be off for 2 years before he could run. And one of the instances in there, uh, uh, Justice Brooks questioned one of the tribal council members and asked him specifically, he said, do you believe that the tribal council has the power to write disqualifications for people to run for office that are outside the Constitution? Of course, the tribal member said yes. But here's the other thing in that. If you treat people differently, it's unconstitutional. Now, who else in the tribe cannot run for tribal office? Is there anybody else who cannot run? Because we all know this ordinance was written as a knee-jerk reaction to an alleged situation with the Board of Elections. So what we're saying here essentially is, well, if you're on the Board of Elections, you need a 2-year, they call it a cooling off period. Why? Because you sat there and you had access to all the enrollment offices. And so if you're going to run for office, you might have an unfair advantage. So they've stuck in here a 2-year cooling off period. Well, then let's not treat people differently, because let's look at the chairman. The chairman's going to run for re-election. Now, his office is right down the hall from the enrollment office. Are you going to tell me that if the chairman wants access to the enrollment records, he can't have it? And are we going to tell him he's got to wait for 2 years before he can run for re-election? Of course not, because we're treating him differently, because we're treating him like he has integrity. He would never do that. But we're not doing that with Board of Election members because they don't have integrity. So they got to be away from the Board of Elections for 2 years. Well, what about somebody in the enrollment office who's been there? Miss Raina's been in the enrollment office for over 15 years. What if she files to run for tribal council? What are we going to tell her? You're not going to tell her she can't run. So you're treating people differently in the tribe. And when you do that, folks, they don't have justice, they don't have freedom, and they surely can't run for office. That is treating them unconstitutionally. That makes this whole situation unconstitutional.
Like, is anybody required to serve on the elections board?
Excuse me?
Are you required to serve on the elections board?
No,
It is at your election, right?
I'm sorry. I couldn't.
You get to choose to be on it or not, or you can choose to be on it or not.
I presume.
I think that's what this case is about. That's really what it's about. You asked the question, Mr. Locklear, that you're not seeing how that ordinance is a violation. Here's where the court's at.
You would please. Just would. The reason why I asked earlier in regards to he only believes that the only limitation that can be placed on running is the Constitution because of a felon. I don't think that can be completely accurate. I mean, there's going to be situations, there's going to be things that cause a governing body to have to say that, okay, we got to place some safeguards in place.
Can you give us an example? Or an example of that happening? Read.
23, 2023, 2020.
No, in our
Oh,
tribal
over the
government's
24
existence,
years
has
of
that ever
existence.
happened? I'm
I
not,
think that's specifically what she alluded to, is what she returned as a knee-jerk reaction was actually a case that happened in 20, where a member immediately left the Board of Elections, jumped into an election, and then was using information, enrollment data, addresses,
Allegedly was using.
but we can parse over the allegedly. But as the case, the documents only had been ascertained by somebody particularly situated upon the elections board. So that would be the greatest example, I think, of why there should be some safeguard for allowing or placing a limitation, the ability to run, or a cooling off period, as we referred it to, such that you are so far removed from that information, there's no longer a concern or the appearance of an impropriety that could occur as a result of your service. Well, the point was that not required to be a member of the election, choose to serve in that position, choose subject to the requirements of the service. That would be my point.
Mr. Lockletter, along those lines, what about the point that Ms. Blanks made regarding the double chair having access to that same information? Also,
The difference is that he's in an elected position outside of the election board itself. He's already a step removed from the intimacy of that process. Talking about somebody who governs the elections themselves, whose hands are on the wheel at all times. We're making the calls when it comes down to whether somebody voted illegally or voted out of district. They're the people making those decisions. They have a very intimate knowledge and understanding of the election process, and they're also entangled. It's their entanglement that you're pulling off period for, move them from the process. By time itself is really the only thing we have. Chairman is not entangled by those obligations. It's not his job to be involved in that election. So him being down the hall, down the hall from finance, but you don't get a new vehicle from down there. So I think that because of intimacy with the elections, the reason why the cooling off period is, chairman doesn't have access, but they're not similarly situated. That would be mine.
Ms. Blanks, can a tribal person, a tribal member, voluntarily and knowingly waive their consent, waive their right to run for council?
I don't, mean, you can either run or not run. I don't know that you could waive it.
If a condition to serve on a particular board was that you not run for tribal council, knowingly accept that condition and serve on that board?
I suppose you could, but it's still a unconstitutional requirement. Even if, it's like saying, okay, I'm going to join the army. The army's got certain provisions. There are certain things you can't do, but it's also like saying, okay, you're a soldier, but you can't vote. You may waive your right to vote, but it would still be unconstitutional to tell soldiers they couldn't vote.
Ms. Blanks, if a tribal council person is removed in accordance with seven article, right, yes, Article 7 for missing 3 consecutive regularly scheduled,
Mhm.
and they're, unexcused, their position that that tribal person can then run again in the next election, happens again, they can run again.
There's no provision that says they cannot.
Thank you.
Mr. Locklear, does the council believe that a good faith belief that something will grant them authority? The reason why I ask that is because it appears that you've laid out a very strong basis why election. The explanation is that council needs this because of potential impropriety by elections board members that could use it and weaponize it in an election. If that's true, I don't believe that anyone's disputing it. Harmful. Would that give the council constitutional authority to do something that guys wouldn't?
I think they have the constitutional authority that act. Ergo, how you frame that statement, I think they have the constitutional authority to put in place necessary for a variety of things. I don't think that the fact that Constitution they can not allow somebody to run because they were a felon. The only thing, all that does is tell us that there are something they, in the creation of the Constitution, identified as being necessary to allow the council to limit. So the fact that it's there tells me that there was something and there was a reason for the framers of the Constitution to provide that authority. Council don't see it as a limitation or a stop that authority. I don't think it was created. Now that's you can go back and forth. Yeah. My point is that the authority, and I want to be clear, it doesn't stop somebody from as it would if you were a felon. So I think that also another thing we can look at in terms of Constitution limited it. You can't run if you're a felon or you have the council is given the authority to make that declaration. That's not what's in the case. It's really conditioning your ability to run. As it did conditioning the ability to run if you serve 2 consecutive terms. But that's another condition.
Let me read Article 3. Ms. Blanks actually, she cites this in her petition. Article 3, Section 1. Powers expressed herein. Those powers necessary and proper to the exercise of those powers expressed here are delegated to by the general membership of the Lumbee Tribe of North Carolina. Those powers not delegated are reserved by the general membership of the tribe. Can you tell the court where the powers are delegated here in the Constitution that would give the tribal council the authority to place this election for office?
Article 10, Section promulgate necessary and appropriate regulations of the authority of this Constitution and tribal ordinances governing the administration and conduct of all regular and tribal elections. They are to perform their actions under the authority granted by the tribal ordinances, so govern the voter registration and the conduct of all regular. Especially, that is where I derive
Article 10,
Section 1, subsection A. They're given the power to promulgate necessary and appropriate regulations under authority of this Constitution and the tribal ordinances governing voter registration and the conduct of all.
what would you say in response to that?
I would say that he's reading the Elections Board article, and the Constitution states, first of all, that they are an independent board, for one thing, and it states what their authority is. But it also states that promulgate necessary and appropriate regulations under the authority of the Constitution and tribal ordinances. And it says these ordinances govern voter registration and the conduct of regular and special tribal elections. It says nothing about the tribal elections board. Doesn't give them any special power over the tribal elections board. Specifically states they are an independent board.
We had a previous Supreme Court tribal hearing, and I can't remember what it was, but we spent a great deal of time for I can't remember which, but there was opinions all over the place as to what promulgate. Yeah, some folks hate, some folks believe that as it relates to that provision, in your opinion, but is it the council's position that it is necessary and appropriate that elections board members be on their ability to run for office outside those two? That section.
Necessary and appropriate for election members to have that 2 year placed on them.
Yes.
Yeah, but I weren't done. Places to refer to power.
Okay.
So if we also look at Article 2 membership and go to Section 4, voting general membership shall consist of those members of the tribe who are 18 and older and who are registered voters in accordance with duly adopted tribal ordinances. I think there would also give you power to put in place matters or requirements for voting for general members. I know it's not specifically the running, it is the voting. It does confer power, involve themselves in an elections process there as well. If we go back to the elections board, Article 10, C, any other matters specified herein or authorized by tribal ordinance. But also there covers any ordinance adopted by the tribal council. They have to promulgate certain appropriate regulations, abide by those rules.
Just looking at the election ordinance that's been provided, Section 3. Number 1 is verifying that a person qualifications for Article 2 will be constituted ordinance. Number 2, verifying candidate. Number 3, verifying petition for measure. Number 4, supervising elections for candidates. But those items not be the things of which article in section, those not be requirements that the election board are expected to promulgate?
Taking it.
And I'm asking you, is there, would the elections board be expected to promulgate their oaths and duties? I'm reading the elections. One where Ms. Blanks has alleged or is in violation. I'm reading. It's labeled oath. Were you Article 10, Section 1, subsection promulgate? My question, would these not be the regular, or are these not the regular? Article 10.
Certainly not limited. Court submission. Section 2, number 4. Wrong place.
How would a person promulgate? How would an election promulgate? Section, subsection.
Will be within the offer to.
I don't know if the court has offered a ruling. I'll look it up. Sounds close to propagate. My recollection was about effect.
Yeah. One is to promote or make widely known an idea or cause and put a law or decree into effect by official proclamation. Those are the two that's Oxford.
The previous case, and I don't recall which one, section come up with own requirement. And issue was whether or not the elections board had the authority to create that every person in the pool could abide by. And the court's conclusion in that matter was that promulgate not the equivalent of create. Pass, that is limited to tribal council, has the ability to create and pass laws. For the elections board to promulgate is for them to basically carry out the duties which have been entrusted by the tribal council. So what I'm asking is how, if that's the definition, promulgate is to carry out. How would an elections board member carry out section? It doesn't appear to be a duty. It doesn't appear to be a task. It doesn't a regulation or a rule responsibility. It appears to be a qualification or a prerequisite. Is the other justices comments?
Also, it's under disqualification and replacement of the board and alternates, but it is not a disqualification because number 4 happens only after you are no longer on the board. So it's not a disqualification.
Let me ask this, Buckler. Does the tribal council believe it has the authority to enter a rule that says an elections board member ever run for office?
I don't think that would be appropriate.
And
I'll
this,
simply state no.
I'm not trying to put the council in a, or even ask that, because now I'm gonna ask, what would be the distinction that saying that a person,
What would be the difference in a rule forever and a 2-year?
as it relates to tribal council's authority, not as in wisdom of it, not as why it would, only as it relates to the tribal council's authority. Council has the authority to pass 2 years. Why wouldn't they have the authority to restrict them?
Isolated to this singular question. Or the reason I ask that is because if that's the position presented, that's the paradox in our Constitution. Time limit could be placed as you're considered. That the Constitution states specifically that's the one that you can't run if you're a felon if council so deems. That would be the way I'd answer that question. I understand what it is you're approaching, but if I'm positioned and that's the question, then that's the
I think
I would
that's,
give.
I don't want to speak for you, I am, but I'm thinking that that's what you say. Well, that's exactly right. The Constitution says the council can only bar persons for felons. It specifically says that in the Constitution.
Hmm.
How is passing an ordinance that specifically restricts this other class of person, right? Not felons. How does that not exceed the scope of the tribal council's authority?
On that basis, I would question the entire Constitution because there are limits on the versus whatever else. There's limits throughout that provide a structure, so to speak, one would run. So
But in fairness,
if
those restrictions are specifically created
hmm,
where they live.
let's say I'm outside of that, then that would be a limit, right?
Yes,
But you also stated that the Constitution provides that the only limit is the one in regards to a felon. So it's in duplicitous.
I'm saying the Constitution only limit that the tribal council is only one that's
Okay,
expressly
I'll,
enumerated.
I'll go down that vein. But understanding, even if you take the Constitution, changeable, bendable. I mean, it's not a concrete document. It's made to be breathing. I think that the time came when steps taken by the council necessary because of prior actions by board members. Where there wasn't a need for it, it became a need based on the actions of the members on that board. Safeguards was put into place. And it's not a limitation, it's merely a condition. If you accept the board, you're going to have to wait 2 years to run. We're not telling you can't run. Just saying we're going to remove you from the process so that nobody can question your integrity when you do run.
So I guess this question is either from or Locklear. How many instances, how many occurrences, either of you know, where a person has served on the election board, has resigned, and has ran for? And if so, the result?
The case that I referenced earlier was that exact situation. And of course, the court allowed him to run.
And educate me, Mr. Jones won that. Mr. Locklear, are you aware of an instance? Someone was on the board, dying, for council and he was elected.
Would the court allow me to call Mr. Answer directly involved during that time?
So I'm gonna give a little backlog of why that ordinance. So when you get ready to run for tribal council or tribal chairman, you are not allowed to get enrollment address, names of enrolled members, whether they're in territory or out of territory. There's a court case with that saying that we're not allowed to receive.
Is that in response to ordinance? Okay, or constitution?
That's a ordinance. Law with that or what. So there, I was running for tribal council in 2018. The person running that I was running against, or we ran against, served as the chief, not the chief, or the chief of the election. Came off in January. No, let's see. She came off in June or July. Filing date is in August. So when it gets ready for the election in November, I asked if I could get enrollment address. No, there's an ordinance that you see those. But my opponent, the one that served as the chairman of the election board, had those names broken down by District 9, in territory and out of territory. So I filed a petition with the Supreme Court with that evidence, and it's clearly enrollment records. So there was a ruling made by the Supreme Court at that time with absentee ballots and all that good stuff, but I won the election. When I won the election and I got elected to council, I said we need to do something about someone that serves on the election board that they have access to that information that other candidates are not allowed to receive. So that ordinance was written to that person serving, whether they're the chairman of the election board or there's an officer on the election board, that there's a cooling off period that they don't have access to that information.
Yeah, may I say something in response to that?
Can I ask a quick question of that
Mhm.
scenario that you just gave? Did the person end up running against you that had access to those records and you won the race, correct? So
Did this happen before? So did the case come up after you had already won?
So the petition was filed during the election period. So we filed for election in August. Came off the election board in either June or July. Filing date was in August. Election was in November. 2 or 3 weeks prior to the election date, that person's campaign manager gave up the records that they were using for their enrollment information.
have an advantage.
Well, they
Didn't
could have
come
had a
close.
they could have had an advantage. They did have an advantage because I didn't have all the members that were from District 9 that lived out of territory.
Prove that you overcome.
But there needs to be the law was written so the next person that comes along that doesn't have that advantage stops that person who had the advantage to.
Happened the very next year in Dr. Oxenine
Jones.
and
And-
Mr. Richard Jones.
Yeah, and I think what the Supreme Court ruled on that was it was term. Word term. What defines a term? That was the Jones and Oxenine was the word. Not serving, it was the term. Whether he served 2 months, 6 months, or 7 months, what defines a term? But that was the whole reason behind that ordinance being written. That nobody doesn't have the upper hand on a candidate that's not allowed to have access to it.
So again, just to be clear, the advantage that we're speaking of did not bear fruit, correct?
No. We won by a landslide.
Won by a landslide because it's work. That's
I mean,
the
that's
point.
what it's supposed to be, but
But
that's the point.
The point is, it doesn't matter if I won or I lost. That person still had the upper hand because they were able to contact everybody that was from that district in territory and out of territory. They live in Baltimore, they live in California.
Why this information private? Why is this information that only persons on the elections board can? Why can't a tribal member get this information? And I'm asking out of ignorance. And why is that privileged?
That was the court ruling. Jones v. Jones, Godwin, back in 2017. Tribal members' addresses, signatures, enrollment numbers does create an unwarranted invasion of personal privacy.
Is it available prior to then?
It used to be.
Sure. Yeah, I
It
was gonna
used
say,
to be.
yeah. Yeah.
So would this case be moot if that information was available to the
Yes.
general public?
Well, you wouldn't need the cooling off period, obviously.
So this also may be why this hasn't been a thing prior to 2018. I was making tribal addresses and contact information private. What's the council's position about tribal information being private?
I mean, if you're running, which we've had this discussion my whole 6 years, sir. I'm running for school board. I can go down to the board of elections and tell them that I want blah, blah, blah. I need that. But when it comes to tribal, which we're sovereign, and we can, because we're sovereign. So, and then my petition, I think the Supreme Court said it was to privacy and all that good stuff.
What if is there a rule that says that a person who becomes a viable candidate for an elections office, that information is made available to the candidates?
For tribal,
Yes. Know that it doesn't exist.
Actually, the ordinance says that you can only give out the information that has been approved by the tribal members. That's the way it's worded, which obviously this information has not been approved by the tribal members, so you can't give it out.
Why does persons on the elections, why are they allowed access?
They have to get the information from enrollment for all the members so that they can get the books and stuff printed out for the elections.
I understand there's a logistical.
To verify your voter rolls, do the polling place, polling books.
Is there a way to restrict a member of the election board ability to access?
I don't imagine how you would find who's in or who's out of this district without knowing the address. It'd be tough, if not impossible.
Why didn't and I'm just talking out loud because I'm processing the basis why this. It sounds, Speaker, spearheaded election ordinance made persons in office on them not being on the election. Could you have not, or could the council not have passed an ordinance? Persons in office?
Yes.
Not at that time, Your Honor. Court had already decided to be outside of their hands.
Why is it not private then? Why does the court that this information is private? Why does it not exclude of the elections?
It's impossible to complete their task without access.
So why can that same standard not be applied to candidates for office?
And what are the conditions? Candidates.
If a candidate would say that it's impossible, in success, campaign for an tribal government without
My best
yeah, I mean, we're just
Yeah.
speculating.
is that I think the privacy concerns that was announced by the court would trump candidates' ability to access merely for the purpose of contact. You can go door to door. You can go to community, meet these people. And in terms of whether or not they should vote, that'll be vetted out at the polls that day. But a candidate holds a function. Everybody there, that don't mean they can all vote for him. All that does is it would steer the candidate away from direct mailings or something in that regard.
Know what the context of work?
It was when, remember, there was a time when somebody was mad with Matt Scott and they were looking for his house. And there were threats that were made and
Yes.
you remember? It
Yes.
was during that time.
Let's take a 5-minute recess. Your legs.
All rise.
Seated. Like you said earlier, in our response to a question, I believe essentially tribal council not have authority ever place a condition on a person's run for office. Is that
Other than what is stated in
Other
it.
than Ms. Locklear, you asked that question. Disagree with her? You believe this is one of those times?
Yes, sir.
How far, if if this case upholds council's authority to be, what would regulate council reach into? How far could they go? How would they know how far they could? And I don't expect you to be able to answer that. I consult with the council members. And let me just say why that's a concern. Let me say why that's a concern. This court, if the opinion that you referenced, I believe that it's Malcolm in that. In his opinion, his closing remarks, he made this, said this court takes expansive authority, tribal council. No question that the tribal council has an expansive power to pass legislation, act legislation that affects every member of this tribe. So my question is that if this court upholds a legislation by this tribal council that restricts a person's ability to run for office, what keeps that in check? How far can they carry that or not carry it?
Will of the people. Membership themselves is the one to elect. They have the power.
How would they restrict?
Recall, referendum, vote them out. That's the power of the people. If that power of the legislative body became too great, it came to the rights of that member. It's inherent upon that membership to be active in.
Would it not be the of this court to ensure that the council not overreach and not the people general membership?
As with any discussion in regards to the separation of powers, can become as fine a line or as broad a stroke as you want it to be. Powers granted by the Constitution, action on behalf of the tribal council. I understand what you're asking. If we can go back to the beginning of this case, I think that's very vital at this moment when you pose. You're preventing harm that was never presented based upon a hypothetical set of facts.
What
So
was?
this very hearing is based on the theory that this may happen
I
to
think
some member of the board.
I think it's an actual controversy. I think that there's an actual ordinance that says persons can't run served on elections for past 2 years. I don't think that's a hypothetical. I think that's an actual ordinance that's in place.
We're not debating the ordinance. that exists. Yeah, it's a real ordinance, but no harm's come of it. And at that moment is when the court, that's when they invoke themselves in and prevent it from happening.
Why would the council not say it's the will of the people, pass an amendment to the Constitution, that if the people want these persons not to be able to run for office, that it should be the will of the people, as not exercise a power that's not enumerated in the Constitution, to pass an amendment to not allow these persons office. Why should the will of the people have to react to the will of the council?
The tribal council is the will. That's its. I would say that's encompassed in the parent. And you go out and you go into the community and say, "I want to represent you," so then I confer on you that power to do so. I think that is the will of the people.
What if, and when I ask what if, I'm asking you to distinguish this from this possibility. What if a tribal council member is elected to the tribal office and they're a blue collar, hard-working person? They get out, they meet the public, but the person that's running against them is a successful business. They have deep pockets. They're millionaires. They can buy more advertising. They can spend more money that the other person can. What would prevent that person getting on the council and passing an ordinance that restricts a person from being able to, restricting a business owner from running for council? If the court were to uphold this ordinance, what would be the decision?
And I want to just clear what would prevent the. What's the prevention? I'm sorry.
So, Miss Blank,
I understand what your premise of the question was. A businessman runs and then guy that's the blue collar, he wins, he gets on there and says, well, a businessman can't run. What
yes.
prevents us from doing, would prevent
what-
the council from doing that?
If this court recognizes the council's authority, that's like, what would prevent the person over here in this class of persons? They're going to have an unfair advantage. What would keep the council from passing an ordinance restricting that person's run if the court upholds this ordinance restricting a person who's on the election based on the perception?
Because this ordinance under elections board ordinance limited in that the only people it affects are those who choose to membership on the election. It isn't the general membership that's affected by this. It is narrowly tailored, specific to those members. That in itself is a safeguard, if you examine it that way, that its exposure is only to a very limited amount of people.
Why shouldn't they have that authority? Why should the council not have that authority?
Because, as I've stated, they're treating people differently. Just like I said, if somebody in the enrollment office wants to file for tribal council office, they have all the information, and have had it for years and years and years. But you're not questioning their integrity. You are questioning the integrity of every election board member when you say they need a cooling off period. You don't say anybody else needs a cooling off period.
Who else has access to that information?
I would assume probably anybody in this building that would want to. You know good and well, if the chairman goes in there and says, I want to see these records, who's going to say, no, chairman, you running for reelection? Is that an unfair advantage for him to have access to those records?
Well,
That means he's being treated differently than somebody on the Board of Elections.
would you disagree that it is a personal election? And then, I mean,
Only if they're a person with no integrity. And these people on this election board are chosen by the tribal council. Tribal council needs to make sure they put people on the election board who are people of integrity. You put them on there and you let them do their job.
That
So-
may be the case, Your Honor, but fine plumbing stuff. I don't know. It's a safeguard. We're not questioning it. It's not a matter of a person's. The person that with integrity would have accepted the position based upon rules and regulations as already existing when they accepted it, would be subject to those. Honor that by not running within the 2-year period. That would be a person of integrity.
How does what initiates a person? They apply for it? Is does the tribal council give a list of nominees? How does that work?
So when there is a vacancy on the election board, it's noted, council reaches out to whatever districts that vacancy falls under. They're interviewed, they're brought out of committee, and then brought forth to the full council for a vote.
Mr. Locklear, I can't recall if this question was answered, but how was the 2-year determination? Why not 6 months? Why not 2.5 years?
Mr. Justice, would you allow me to refer to?
And I'll add to that. What does the cooling off period accomplish?
So enrollment is updated annually. So that gives that person that served on the election board 2 years for those roles to change. For that district, whatever may be.
Does a
Quick. Could the tribal council pass an ordinance? Well, first question, does the tribal council, I understand, does not have access? Could they pass, if not, could they pass an ordinance giving the tribal council?
I suppose in violation.
Case law precedent for the general public typically, or that cannot have access, or is it just no one outside of the? So even the tribal chair, it was referenced earlier that the tribal chair.
Yeah, no one can access it.
And final, going back to the specific voter, going back to the specific ordinance, CLLO 2005-. In the original ordinance and in the current ordinance, number 3 states, a board member files as a candidate for a position in tribal government. The board member's appointment shall be deemed automatically. So was it the intent of the original drafters, they contemplated that a current board member possibly could file for tribal government and they would just be deemed automatically on sort of that day as opposed to a cooling off period?
When number 3 was put into existence, yes.
And did something change other than the perceived advantage? It, again, did not, from what I understand, in an actual advantage. Was number 4 then added? Number 3, not, like sort of in conflict. Original had only number 3 contemplated on the board. I can draw that day. So I guess my question, Mr. Locklear, is what changed from the intent of the draft for this document?
When it was realized how that information could be used to advantage. I can give you 4 numbers to the lottery. I mean, I give you, you're in a far better position than I am that has no numbers at all. So I may win. That's what happened in the case. Just so happened the guy that didn't have the advantage won. But I don't think it should be possible. I do. Yeah, I don't think it was something that was an incident as occurring, being necessary. But when the incident occurred, it was realized then some safeguard needed to be in place, and that's why it was.
Surely the original drafters would have known that on the board, the election board in 2005 through 2019 had access, and even though knowing that, they did draft the ordinance saying, yes, we know you have access, but officer.
Mr. Kelvin, it weren't until 2017 private information. So 17, the case happened in 18, change happened in 19. So all came and after everything happened in that succession.
Ms. Banks, do you in that member of the city you can as a
I don't believe.
thing? So that example earlier of the not extend
No, the chairman's
or
office is down the
Councilman
hall
Baker.
from enrollment. He is the chairman. No. Wants to see enrollment records, he's going to be allowed to see enrollment records. But also, if you look in the Constitution initially, before they even had the vote in 2003, you'll see that the authors of the Constitution allowed the current tribal council members to not only run for office in 2003, the November election, they also served as the Board of Election, and they had the authority to, and here's your word again, promulgate rules and regulations to govern that election. They didn't see a problem with it. That's in the Constitution.
Ms. Blanks, if I can go back to an earlier question that mentioned, if you join the military, you don't. When I voluntarily joined Air Force, I did give up my right to run for a certain office. My constitutional right, my right as an American, run for a certain elected position. Difference here when someone voluntarily joins the board with for a period of time their, and I'll say constitutional right to run for office.
Well, and you said certain political offices. Political offices. You couldn't run for president?
Not while I'm
You
actively
couldn't run
serving,
for Congress? You couldn't run for, were there offices you could run for?
not that I'm aware of, not while I was and I'm trying to think of I mean, and again, I'm asking a question where I'm open to being corrected. Think of a local office, current, I'm military, an elected, because they have waived that right, that
I don't know, unless it has to do with residency or that kind of stuff. But no.
Person not have a constitutional right under our constitution.
Yes.
So, given that it's not a right, is say that it fall under, would it still violate the Constitution? Person consent, waive their constitution, run for chairman in order to serve on the election.
I did this before, not sure about the waiving. The way that I'm looking at this is that everybody able to run for office and everything in here, there's nothing to dissuade people to run for office, nothing. It gives the council the authority. It tells you, okay, here's who qualifies, here's who doesn't qualify. If you so decide, just like with the felon, they had the option. They didn't have to make them ineligible. Tells me again that they were looking for people to be eligible to run for office. So for the council to then go in and put in another disqualification is unconstitutional. They simply don't have that authority. Nothing in this document would lend to that, to give them that power.
But you, Mr. Locklear made a point earlier, you would not disagree that a person's right to run for office is not barred as long as they just opt not to serve on the. Wouldn't disagree with that.
If you don't want to serve on the election board, then you don't have to run. You're not ruled by this ordinance. Is that what you're saying?
Yes. So, you know, if it's 2024, there's an election likely coming in 2016. I may have thoughts about running in that election, but I know that if I undertake this responsibility to serve on the elections, I'm going to give up that right to be. What's wrong with that?
What's wrong with that is the fact that it is unconstitutional to require that.
There we have our disagreement. Council believes that it has the authority to require a person to waive that. Argument again. That is unconstitutional. Require that of a person. Ask them to serve in that capacity. The only way they can serve.
Already down to have the on our side, have case law, our problem. It had to be corrected by could have been presentation as a show, not an instance where it's harmed someone from running because of the ordinance.
Well, let me ask you, why did you allow him that court case? 920. Why did you allow Richard Jones to run?
Gonna make me walk the plank. The court rendered a decision,
I couldn't hear the
and
decision.
I realized the audio was not that great. I'm gonna be transparent. That was my first case on this court. I was pretty convinced the argument that you're making, pretty convinced that the only restrictions that can be placed upon person's ability to run for tribal office has to be court. We came back in that we believe your period that was assigned by the council was words arbitrary. That's basically legal words for unreasonable. And the ruling that the court made is that a 1-year cooling off period. I'm really surprised that that was brought up. I stipulated that was not. Party has not been a. We could have come in here tonight. We could have. Court's already heard this. The court's already ruled on this. Court has already decided. Heard this statute unconstitutional. Could have looked at the council and said, council amended this ordinance to reflect the 1-year cooling off period as decided by the court.
No.
And I suppose that that would not satisfy Petitioner Blanks because she would. The reason why we've had this hearing because I believe that it's important for the court to try to be as transparent as possible. And for us, this is the most difficult case that I've heard in the court. I've had other cases that have had probably implications that may or may have not been greater. I can't think of one that is constitutional because it's so wacky. This is stuff that you can't anticipate. It's a problem that's been created because of a problem tried to fix, and in fixing it, there's questions of whether or not the problem. So let's just Mr. Jones. I believe it's because we believe that tribal ordinance. How excessive? We weren't willing to go that night and say that it was all the way excessive. We're not willing to go that night and council in passing this ordinance has violated the Constitution. Article 7 that specifies what the are for. There's no other body of persons elections that I can think of that the tribal council unilaterally decides who they are. And yet, the Constitution says that the Elections Board is an independent body, although they are required to promulgate rules and regulations that are legislated by the council. There's balances all over the place. I don't know if that answers your question. Thanks, but thank you. Honest.
But you did not require him to sit out a year.
We did, well, I think Mr. Speaker is correct. The issue in that case really turned on the and I believe that the reason why we did not require him, there was some issue with, I can't recall the details. Oh, you correct.
Don't hold me to. I think it was less than appointed for the council.
I can help you out a little bit. He actually was appointed prior to written. He was appointed in February of that year of 19, and then he filed, I think, in August.
What's the council's position on
Council's position is 1 year position because of the enrollment renewal happen on a year basis. Found that by some point in the old rule, the old rules would be the rule. Get beyond that, outside the modifications, which completely removes them from the process. Also, back to that legal conundrum. Yeah, because of that, that was the big example. Important conversation. Can't just 1 year because it's still within same information is available in the 1 year. You have to go at least 2 years on that information. Remove the person from.
Do you Blanks, do you believe that the council has the authority to come up with qualifications?
Because
I know you have
the
a
Constitution says, all it says is that they have to be over 18 years old.
So does that mean then that the election, or that the council has to accept application on the election? What criteria could they use from
Over 18 is eligible to be on the board, but the council themselves, I mean, typically, when you put because they appoint the person, and normally it's somebody they know, somebody that they, or somebody they know knows. It's not like somebody just comes in and hands you a resume and you just stick them on the board. That's not the way it is. Normally they know the person they're putting on there.
Well, there is a way that the council, or just like the Supreme Court or the Administrative Court. So it's got to be stipulated on who we can put on the list. It's got to come from a certain district. Can't have election board with everybody from District 9 on there. It's not fair to all the other 13 districts.
How many members are on the election?
5. And those five seats are broken up between the 4 now and the travel territory.
Judging it where possible. Council.
Council not bend ordinance. This is not an interrogation. I'm just in the same reason why the court didn't write an opinion.
This similar to the question that we asked. Didn't make 1 year adequately.
Sounds like defiance. Sounds
Well,
like
there is separation of powers.
you're not suggesting council by the final.
No, I wasn't even aware of that. Figure out that decision, money down. It weren't never published. I don't know how we'd even know. I've asked some council members, and they're like they had never heard of it. It weren't never published,
That's fair.
and
That's fair.
weren't on the website. So Mr. Roller found it and sent it out in an email to everybody. So I wasn't even around in 2019, whatever this was. We had the pandemic on.
I don't want us to be like we were in. Take another 5 to 10 minutes. Justices have any questions? Great.
All rise.
So a question and or statement from parties looking at Columbia Constitution, Article 11, complete duty of loyalty. Parties of I apologize. This is every elected and appointed tribal official empowered herein shall affirm upon taking office that he or she will abide by the Constitution, laws of the tribe of North Carolina, and will, his or her ability, his or her loyalty, to the Lumbee tribe of North Carolina. Section 2, the first tribal council shall adopt prescribing conflicts of interest in the performance of elected and tribal officials, which ordinance shall require a tribal official or herself or vote his or her pecuniary interest or a family member. What you don't have in front of you, and I'm apologize, section of ordinance number 008, dated amended CLLO 312. One title F, subsection 1B, shall not use information that is gained the execution of his or her office or employment that is not available to the general public, further or seek to further the person's private. So Ms. Blank specifically see where possibly someone who's performing their duty as a Board of Election member would have access to information personal, i.e. running for tribal council.
Yes.
In light of that, Ms. Blank, you believe they would have a duty for Article 11, themselves running for elect office, given Article 11 ethics?
No, not unless the same thing applied to the chairman or anyone else who had access to that same information.
And Chief, if I may, I'm not sure it has been established, at least in my opinion, that the chair, it has not been shown, and in my opinion, that does have access. I guess speculated that because of petition, they could go down there and demand access, but I'm not sure it's been shown unless I'm corrected.
It's been assumed.
Right.
I don't think it's been established customary. But based on what it appears is the undisputed person not only has access that is not available to them, can't do their jobs unless they access and utilize him. Fair?
Yes.
And so, in light of that, in light of Article 11, Section 2, I'm going to ask the council for this kind of effort. Thanks to would a person serving as an election board member has intimate access to private information not available to the general public, would they not increase their pecuniary interest by deciding to resign from their post at elections?
Well, as I understand it, the pecuniary interest refers to money. Surely you're not thinking that you get money on the tribal council.
Well, it doesn't say, it doesn't say how much the pecuniary interest there is not limited. And the statute that Justice Jacobs read, what was the language that was used? Maybe it was personal, private. Section 1. They shall not use information that is gained in the execution of his or her office or employment that is not available for public, further or person private. Would that not be word for word conduct person on the election finds during their term on the election public office?
If that's the situation, looks like that would have been addressed in this ethics ordinance. No, it is not.
And again, we're back to that issue where problems, almost like renovating. Go to fix one thing, fix it, or tore up two other things.
Right.
I mean, it's hard to govern, isn't it?
But can I throw a monkey wrench in all of this?
Just don't hit.
I used to play softball. The situation that we're talking about that started all of this amendment. I just at the court case, which was an court case because the alleged person was not included, but the information that was provided that said that this person got this information from the Board of Elections is false. And I know this because when I ran for office, they didn't give you any information, but they used to give out this information. So the person who had the office before me had been there for 6 years, and he had a list which he gave to me.
A list
of voter names for District 9. That was my district. So I had those.
Okay.
Now, the list that they're talking about that Sheila had was this same list.
Okay.
That list, so that means I went on the council in 2013. So this was a list he had obviously at least 3 years earlier. Sheila ran 6 years after I went on. So this, when they're talking about updating the rolls every year and getting all this fresh new information, the list Sheila had to have been at least from 2009.
So in fairness to the council,
She did not get this information. What I'm saying is she didn't get this information from the Board of Elections.
so in fairness to the council, after 2017, she wouldn't have been able to have gotten that information, but for being
But see,
made it private.
he's saying that there's an alleged, that I'm saying that there's an alleged situation that could perhaps happen. And I'm saying that the situation that they're talking about didn't happen.
Outside of all the speculation, allegations, and what is or where it might have come from. She was sitting on the board at the time and happened to have it. If it wasn't
After the court
inappropriate,
had determined that it was private.
yeah, whether it's inappropriate or not, sure seems to be.
But that is not
I don't
the
know. I'm
allegations
just saying.
were.
What is the council's thoughts on this Article 11, Section 1, Article 1, Section?
There is a pecuniary interest coming.
Council ethic, that Article 11 and the ethics ordinance, that would provide a constant basis whereby they could restrict a person office that has access to.
Yes.
Then how do you deal with somebody who works in enrollment, who has access to this information? Let's say the chairman doesn't. Somebody in enrollment surely has it.
An employee.
An employee surely has access to this information. Can you restrict them from running for office?
Is there a provision in the ethics ordinance for employee tribe for office within a certain time?
Okay.
There is an ordinance in the ethics violation. Leave office employee.
Not anymore. They
with-
changed it last year.
It's still in there. It's still in there.
They removed that provision last year.
In there as of this year, last year. Whatever we done.
Good.
I was there. The difference was in the time period in which
They removed
So-
they removed that whole statement.
So I'm going to take
I'm
us farther and there's a
Judge,
united,
we're talking about the elections because they're the perfunctory handles the election. That's register.
there's a United States Supreme Court case, and I'm not saying that this court is beholden to what the United States Supreme Court. I think it's built for the Supreme Court of the United States in a case called Powell versus McCormick. They decided that the Constitution has exclusive authority on deciding what qualifications are for a person, because Congress passed an ordinance excluding a person from being able to run from Congress and joining them based on ethics violations engaged in. And the Supreme Court, I believe Justice Warren was the Chief Justice, one that wrote the opinion, stated that Congress did not have the authority to write a law that restricted a person's qualification, exclude them from office. But expulsion was a different. Why can the council not act in a matter to expel a person from the council who they believe violates this ethics by leaving the elections during their term and that information, running for office, gaining a seat on the election, on the tribal council? Why then not hold that person expelled?
If I understand correctly, you mean let them run, let them get seated, then kick them off?
Yes.
Because we wouldn't want to engage in anything to subvert the will. They're the ones who are voting for this candidate on the basis that they're qualified to run.
Yeah, but Mr. Locklear, if you go that way, aren't you subverting the will of the people by not letting them vote first?
We didn't stop them from voting. Only thing that we did was they win, they could run. Not a limitation, just a condition.
What do you say to that, Ms. Blanks, that it's not a restriction? That's your words?
It
That's your
says
language?
I
you
was just saying
shall
it was a
not
condition
run
of
for
your service on
office.
the board. Condition of the service.
It says you shall not run.
Or 2 years,
2 years, 10 years, 20 years, shall not run.
or 2 years.
Go back to the judge's argument. Difference in 2 years and forever.
But would the council be able to act in order to win that?
Did they kick somebody off?
Yes. On the, is everyone familiar with, what's the representative in New York's name, Santos? Y'all familiar with that? Where he was just
New
recently
York,
expelled in the past year
the
in
New
New
York guy.
So
I don't.
the election, the ethics ordinance.
Sanctions. I
Sanctions.
know there's sanctions. Ultimately can lead to expulsion.
Just if I may, under, and if, notice that this has been several times and has been, but I'm not sure if it's still in effect. So with that context, I'm not sure if the definition has. I'm going to read a definition from the definitions. Ms. Blanks, I'm going to ask you to think this would be a problem. Person on the Board of Election from resigning for tribal council. A member has a conflict of interest. A member exercises an official power or performs an official duty or function in the execution of his or her office, and at the same time knows that in the performance of the duty or function or in the exercise power there is opportunity to further his or her private and or personal interest. So my specific question is, does a Board of Election member have a conflict of interest when they go run, when they resign in an election? They have a duty.
And I'm sorry, I'm looking at that. Which section was that?
I was reading.
And so your question for that is what now?
Does an appointed elections board member, first of all, are you of the belief that this ordinance would apply to them?
I believe this is for Tribal council officer. Appointees. This is for members of the board of election.
So with that, they would have based on the definition, a conflict of interest from running tribal council.
I don't know if that's from running. I mean, it says there's a conflict of interest. There's also a section that tells you how you handle the conflict of interest, but it says nothing about being able to run for office.
Well, let's just say for the sake.
Okay.
Let's say a person's on the elections board right now. And next filing period, they resign from the elections board and they have a conflict of interest.
I'm sorry.
Person serving on the elections board, next election cycle comes up, they find out when the open filing period begins, they resign from the elections board and they announce their candidacy. Determine whether it's the tribal council. That person have a conflict of interest.
No.
Why?
What is a conflict of interest? I mean, what's your
Well, Mr. Justice Jacobs read
right?
in the ethics ordinance that a person cannot use private information that is not available to the general public.
Are you assuming they're using private information?
Can they unsee things that they've had to in order to perform the job?
Are you assuming that somebody can remember 2,500 names
If I
and
may, Chief
addresses?
Justice, would they have a perceived conflict of interest?
Well, here's the thing. It's been going on for years. Nobody's had any perceived conflict of interest. There was not a perceived conflict of interest when Mr. Jones was allowed to run. He had access to that information. Why would it be different for anybody else?
I think that's an important question. I think the court in rendering and coming to a decision case, it matters whether or not the court is convinced the person who is acting as a elections board member resigns and then seeks office. How could they not be in violation of an ordinance that says cannot use information that they get privately, not otherwise available?
Understand how you mean they gained it. You saying they took copies of rolls or I mean, just seeing this stuff, you're talking about rolls. Well, actually, they get a CD. Get a CD with 40,000 names on it. So I'm not sure how you're talking about they gained this information.
Well, you've said that as it stands now, members of the tribal council, members of the bench can't know if that person on elections.
They would get a CD with 40,000 names on it. And they're not separated either. So you don't know these names. You don't know what district they're in.
How can a tribunal rely on a person's person that they haven't used something that only they have had access to?
But there again, you're questioning somebody's integrity when you're not questioning anybody else's integrity.
Anybody else being person
Being somebody who could be in the same situation, like the employee, like the chairman, who will run.
I don't dispute.
I don't know how she knows, but does the employee get the 40,000 name CD sent home to them to go through?
It's all on your computer. You haven't seen their screens?
No, I don't go digging.
Oh, sorry. The people who work in enrollment, they have programs with everybody's names and addresses and stuff on it.
Persons in enrollment, are they required to sign any kind of oath saying that they will not donate that information?
No,
I've
I-
never served, I don't know.
no.
You're saying no, they don't have to sign an oath? So
But-
an employee could be to the public?
Yes.
So, I know I have called members of enrollment, and I'm the speaker. They won't tell me nothing. So how even knows how enrollment's broken down, and if it's broken down or not broken down. I've been here 6 years and I've never seen enrollment list.
Yes.
That's not my job to worry about
Well-
enrollment.
Don't say you don't know how I do it, because I did ask.
What year did you ask?
Or
When did you request the information?
I asked questions about the process, not requesting information. But when you have an election, just like I did, and you have the mail-in ballots, how do you think they check these people to see whether or not, they have to check and see whether or not these people are enrolled when they request an absentee ballot? They have to have these rolls, and it's in enrollment, and they check to see whether they're actually eligible to receive an absentee ballot. It's all of that information's in enrollment in their programs. That's
Mhm.
how they're doing our redistricting. They've got all these people in the program.
And you have access to this.
I didn't say I had access to
You
that.
said, did you ask? And you said,
I
I
know,
did.
I
So
said that I asked the process, how that works.
you asked the
I've seen
process
that.
later was the response given, but initially you said, did he ask for it? He said no. You said,
He
well,
said
I
he didn't
did
know
ask
how it
for it.
worked.
I'm just trying to figure out how you got information that nobody else does, and then I was trying to figure out when you got the information, if it was prior to the time that it was made private. That's the basis of the question. So
Section 1, subsection ethics. Tribal chairperson, council member, officer, appointee, employee, or any person or entity that provides contractual shall not use information, execution, or office or employee not available for the person's personal. Question is does a person who is on the election board information they have gained to enhance their personal or private interest run for office in the Lumbee? And if that's true, let's just say for the sake of argument, makes if that's true, does that give the council the authority to exclude that person from running for office? I assume that even you, Ms. Blanks, if you were to say, yes, that's a conflict of interest, even if you were to say that it's a conflict of interest, still the council have authority to prevent.
Don't. I mean, as it's stated in this Constitution, there's nothing in here that shows that you should be able qualify somebody? Nothing.
Mr. Locklear, I'm asking you to make closing remark, argument on behalf of the council.
On behalf of the tribal council, our position authority to write the ordinance. And we've covered a lot. It's 3 hours of, a lot of different statute ordinances and rules, from ethics to standing. So in light of all of that, the ruling being placed, it's necessary that standing be established. Power to enact this ordinance to address one initial concern was not arbitrary and capricious because it was based upon information, that normal process and how these roles are updated for elections on a yearly basis. So the 2 years was put in place to give the person that was currently serving on the election outside of that 1 year window where the information they have wasn't the most current. So that was just to provide space so that the appearance of impropriety could at least exist. Furthermore, hey, here's the most crucial point. I could go on talking about all these statutes. When the court made the determination, this turns on whether or not we disagree on does the party then 2 years, should that be the rule or not? I'll go back to the beginning. This arose all issue that came out of an election, an election board member trying to run. That was the harm identified. That was the harm addressed. That was the problem that occurred that caused this creation. That being the case, no point as an election board member been denied a right because of the. We get that's the nexus. That's the bonus that originated everything in this out of. But the ability to make that ordinance and put it in place is the authority of the tribe, buying through the elections board statute, and then the Article 7 powers that they have the authority to write law. Moving past that, if you want to look at the last thing we discussed, civil loyalty, all these things in conjunction convey one single idea. We are to be above board. We are to put in place safeguards to ensure fair and adequate. Nobody should have a greater advantage than the other. That is what was in place, and the ordinance was put in place to support that, to further that. Nobody's been attacked. Nobody's been absolutely denied. Merely a 2-year limitation for those board members who aren't required to serve. It is upon your election to do so. That is a condition of the office when accepted. You don't have to accept it. Knowing that, I don't think it's an overreach. I don't think it's excessive. I think it's a very well measured response to the concern that was raised out of a court case, to the privacy concerns that's been addressed by the court. All of those things led to this point where this ordinance was necessarily created and amended to address an evolving situation, so that we are better prepared to move forward, so we aren't stuck in a situation as you like to address, that once somebody's been elected, we then realize that we now got to remove them because of the violations that occurred. It's a limited preemption. I don't know how else to characterize it, but it doesn't in no way deny a constitutional right to run for office. That would be my final position.
We have where the Constitution states those powers not delegated herein are reserved by the general membership of the tribe. Herein means in this document. If the powers are not given to you in this document, You do not have them. It's plain and simple. We've already gone over the qualifications to run for office. We've already gone over the disqualifications that are allowed by the tribal council. So when you read this constitution, we're looking at the Board of Election members like they have no integrity. And yet, when you read this constitution and you look at the power that's given to the Board of Election in a recall power, the membership has the power for a recall, but do you know what happens if that recall is successful? The election board shall declare the office vacant. Vacant. If the tribal council member or the chairman is recalled, the tribal council is not the one who declares it. The Board of Elections says he is out. That's the power given by the Constitution on an initiative. Again, this is by the general membership. On and if it passes, you know what happens? The tribal board shall declare an ordinance duly inactive. This tribal membership can write an ordinance, and if it's voted in, the Board of Election, not the tribal council, declares that ordinance enacted. The same thing with a referendum. The people can have a referendum. The tribal Board of Elections can declare an ordinance rescinded. They can take an ordinance from the tribal council. That's the power of the people, and that's the power given to the Board of Election in this constitution. And yet we're looking at them, we're treating them as second-class citizens, saying, well, because you served on this board, you don't have any integrity, so now you got to sit out 2 years before you can run for an elected office. Doesn't sound like to me that's the way that the authors of this document thought about the Board of Elections, independent Board of Election. Any way you look at it, it is unconstitutional. Single out a party and tell them they cannot run for an elected office of the Lummi.
Thank you. Thank both parties. And I am not going to have a decision. And I don't think you just find that home. Here's what the court is going to ask. The court is going to ask both sides brief. Court does intend reasonably foreseeable. Calling us back for there is much. And it's not just the fact that we have to consider based on what happened. We have to consider because what we decide today break. It's not something likely. Don't get called on all that often, but when we get called on, we seriously. Politeness. Open and recess this. Turn for this.
Rise.